JAL Skills-Based Training. Part 3. Topical Areas Applicable to All Proceedings. Sections 15, 16, 18, and 19. In this final portion of Section 3, we will discuss a series of topics that a GAL should be familiar with or may need to know based on the client or case. These topics include a child's transition from foster care, non-adversarial case resolution, DFS case plans, and incarcerated parents. Let's start by looking at independent living services and permanency planning as a child transitions from foster care. Independent living services extends assistance to foster youth up to age 21 and helps prepare older youth as they age out of the system. It is imperative to ensure foster youth aging out of the system start planning for this transition early and access these independent living services to assist them. Independent living services offer assistance in helping to obtain a high school diploma and vocational training and job placement services. In addition, they provide substance abuse prevention services and, if needed, preventative health activities such as smoking avoidance, nutritional education, and pregnancy prevention. They can also help with preparation to enter post-secondary training and education institutions and help with personal and emotional support through mentors and the promotion of interactions with dedicated adults. A permanency pact creates a formalized, facilitated process which connects foster care youth and a supportive adult to help them transition out of the system. A permanency pact provides both structure and a safety net for the youth, a defined and verbalized commitment by both parties to a long-term supportive relationship, and clarity regarding the expectations of the relationship. The process of establishing a permanency pact consists of the following steps. First, a facilitator will engage the youth to identify the type of support he wants and needs during and after his transition to adulthood. Together, they will establish a list of adults who may be able to fulfill some of those supports. The facilitator will then obtain necessary releases of information, make initial contact with the adults that have been identified, contact and update those adults regarding the youth's current situation, and gauge the adult's level of interest. For those adults who agree to participate, the facilitator will assist in identifying possible supports they are willing and able to provide, and then schedule and facilitate the permanency pact meeting between the foster youth and participating adults. There is a list of 45 suggested supports associated with the permanency pact that supportive adults can reference and might offer to the youth transitioning from care. To symbolize the importance of the commitment, it is recommended that a ceremony or celebration be held to authenticate the permanency pact. While some clients do stay in foster care until they age out of the system, for most of the clients, you will have some interaction with their family along the way, and you will need to be able to find a way to work with them effectively. The next topic looks at the concept of non-adversarial case resolution. Professionals who work with children and parents have become increasingly dissatisfied with the customary reliance on the traditional adversarial system in resolving family-related disputes. Cases and families in juvenile court can be referred to a non-adversarial case resolution (NACR) program, or they can be ordered into NACR by the court. These options will vary by county throughout the state. Your job as the GAL is to represent your client's interests in these processes the same way you would in the court process. Mediation is an accepted form of NACR. A successful mediation implies deliberation that results in solutions that are accepted by the contending parties. Mediation is widely used today in custody disputes between parents nationwide, and it is increasingly found in many juvenile delinquency, juvenile status offender, and child welfare proceedings. Arbitration involves a more formal deliberation with the understanding that the results will be binding on the contending parties. So far, Wyoming is using NACR in juvenile court on a limited basis. Family group conferencing is a form of NACR that involves engaging extended family members of a child and does not necessarily require mediation. Family group counseling is a family-focused, strengths-oriented, community-based approach that involves parents, extended family members, and others to make decisions for children involved in the child welfare system. In Wyoming, it is not often used. Family Partnership Conferencing, FPC, is a modified version of the Family Team Conferencing model. Wraparound services are a foundation to many of these models. Instead of all of the critical decisions for the family being made solely by professionals, Family Partnership Conferencing allows people who know and care about the family members to be involved in finding solutions to their family crisis. Family group and family team conferencing gather family members, friends, professionals, and other interested individuals who join together to improve the lives and functioning of all the members of a specific family. In Wyoming, this is typically conducted by DFS and involves the client's family. As a GAL, you may be asked to participate in a permanency roundtable for your client. These meetings are meant to facilitate out-of-the-box thinking to help expedite permanency for your client. Signs of safety is another method of reviewing and working with families that is being introduced and utilized in areas of the state. Signs of Safety uses mainly the same tools used in family partnerships and permanency roundtables. The wraparound process is an intensive, individualized care management process for children and youth with serious or complex needs. The wraparound process is a team approach which includes family members and other natural supports, service providers, and agencies. The team collaboratively develops an individualized plan of care, implements the plan, and then evaluates its success over time. The process of engaging the family, convening the team, developing the plan, implementing the plan, and transitioning the youth out of the formal wraparound process is typically facilitated by a trained care manager or wraparound facilitator, sometimes referred to as the family care coordinator. This is also known in Wyoming as high-fidelity wraparound. Permanency packs, FPCs, family group conferencing, permanency roundtables, signs of safety, and wraparound are processes that can be used to expedite permanency for your client. As a GAL, keep an open mind and don't be afraid to participate in these types of processes. When working through a case either through NACR or through a more adversarial process, you will need to make sure you have all the information surrounding the case. One of the key pieces of information you should be familiar with is the DFS case plan. Whenever you begin working with a new child client, you should request and review a copy of her case plan from DFS. A case plan is often referred to in Wyoming as the Family Service Plan. It is a plan for change which should identify strategies for change while maintaining a controlled safety plan. Federal law requires the agency to develop a case plan within 60 days or any time a child is removed from her parent's home. Parents, guardians, and youth are entitled to participate in developing the case plan. The case plan should clearly outline roles and responsibilities of each party, as well as expectations and guidelines for the plan. It is important to review the client's case plan in order to familiarize yourself with all details around the home environment. This background knowledge is key in order to independently investigate the case. Ensure that the background work is done by the caseworker before writing the case plan. If it hasn't been done, then ask that it be completed or motion the court. Before arriving at any conclusions, the caseworker should review contact notes, recorded observations, progress summaries, and any evaluations to identify trends that may impact progress. She should also have conversations with the parents regarding their perceptions of how things are changing, and review and discuss with the parents their general understanding of the issues that caused the court involvement. The caseworker should have conversations with the children about their perceptions while observing their needs. The caseworker builds collateral contacts with service providers, school, healthcare providers, substitute caregivers, relatives, and any other individuals that may be able to provide perceptions on the case plan and the child's progress. Finally, If children were placed to keep them safe, the caseworker must discuss with all parties whether or not conditions for return to the home have been met. Concurrent planning is required and should be developed as a Plan B if the child is unable to be reunified with his parents. This is best done working with the parents to identify what options they have. A caseworker might start such a conversation with questions like, "Have you thought about where your children would live if something happened to you and you passed away? Who might that person be? Why would you choose him? Where does he live?" When reunification seems unlikely, DFS may choose to place the child in a foster adoptive home. This type of concurrent planning shortens the time to permanency since it allows the foster parents to adopt the child if parental rights are terminated. The foster adoptive home option also increases the likelihood that the child will not have to move if the case plan changes. As a GAL, you should be engaging in concurrent planning from the beginning of the case to ensure the child will have permanency if reunification is unsuccessful. Ask the child the same questions you would ask the parents. Where would you like to live if not with your parents, and why? The final topic we want to touch on is the concept of incarcerated parents in juvenile court. There may be times when your child's parent or parents are incarcerated. Incarceration alone is not a ground for termination of parental rights. Title 14 states that in order to terminate rights, the parents must be incarcerated due to the conviction of a felony and that the parent is unfit to have custody of the child. Therefore, unfitness must be proven in addition to the incarceration. Federal law has long required state agencies to demonstrate that reasonable efforts have been made to provide assistance to prevent the unnecessary removal of a child from his home and to reunify him with his family if out-of-home placement needs to occur. Reasonable efforts must be made with parents who are incarcerated until the court relieves DFS of this responsibility. Reasonable efforts are not required when the court determines by clear and convincing evidence that the parent has been convicted of crimes including murder or voluntary manslaughter, or if the parent has committed a felony assault which results in serious bodily injury to a child or the other parent. If parental rights to any other child have been terminated involuntarily, or if the parent abandoned, abused, tortured, or sexually abused the child, then reasonable efforts are not required. And if there are other circumstances which indicate that there is little likelihood of successful reunification, the court may determine that reasonable efforts are not necessary. Each state provides rights of incarcerated parents in relation to the legal welfare system. The Adoption and Safe Families Act requires states to make reasonable efforts to reunite parents with their abused or neglected children. There is evidence that having a child maintain contact with an incarcerated parent improves parent and child attachment. While terminating the rights of some incarcerated parents may be appropriate, the implications should be thoroughly evaluated since the majority of incarcerated parents in prison are in for nonviolent crimes and will be reunited with their children once they are released from prison. When dealing with incarcerated parents, involve them in DFS case planning. Provide them with clear and timely documentation and an immediate assessment of problems that have been brought to the attention of the child or family. Be aware of services available to inmates and provide ongoing support. Preservation of parental rights is both the law and best practice. It also sustains the parent-child bond, decreases the recidivism rate, and helps with family reunification upon re-entry. When an incarcerated parent is located, you should send an introductory letter to him with your contact information, contact the social worker at the prison and learn about programs and services available to inmates, and then arrange a visit to meet with him. Document information on the probable length of stay and be sure DFS includes the parent in case plan preparations and the case plan. Ensure that the court and DFS have the parent's address and inmate number at the facility and understand the mail policy so you don't send things that aren't allowed. Your service as guardian ad litem for children in the state of Wyoming is critical to their future safety and well-being. It is a vitally important occupation. Many times you will find it challenging and even frustrating. We hope you find it rewarding as well. On behalf of your future clients, we thank you for your service.